Okay, good. Dennis is on. No, I'm on. Okay.
Good morning. I'm Rick.
Good morning, everybody. Can you hear me? Thumbs up, maybe? All right, cool.
Yes, sir.
Yes, sir. All right, excellent. Happy Friday, and wish everybody that observes and those that don't a great Friday and a good Friday, capital G and lowercase g as it may be. Welcome to the, I'll call this virtual public hearing to order relating to Senate Bill 569 related to damages for medical monitoring. As we've been through before, if you haven't joined us in these, I'd ask that we've all done a fantastic job in some of these if you've participated of being virtual adults. So I would ask that you try to keep your microphone muted. I will watch for that as well on my end, just so everybody has an opportunity to hear from others, and unmute when you're called on. I'll call on the speaker that is up, and then I will announce who is to follow them. Well, as they say in baseball, I'll announce who's on deck. We observe the rules of decorum and conduct in these meetings as we would in the chamber, and we've had good luck with that, so I would expect nothing less today. Well, now somebody's serenading us. Oh, this is a first. Okay. All right. I'll just mute everybody to start. Although I did really enjoy the musical touch. Let's not speak out of turn, and I'll give everybody 2 minutes. And when your 2 minutes expired, I will tell you to wrap up comments, obviously politely. We are streaming live on our YouTube channel, so your remarks are out in the public sphere. Again, I would appreciate everybody try to keep their remarks as best as we can to 2 minutes. And I will, with that, kick it off. And the first speaker today is Sarah Serber, followed by Ed Hill. Ms. Serber?
All right. It figures I'm first. All right. I'm Dr. Sarah Serber, and I'm an assistant professor at Marshall University as well as a lawyer. I have a PhD in occupational and environmental public health, and for over a decade, I have practiced environmental law and researched public health impacts in West Virginia. I speak in opposition to this bill for its potentially devastating impacts on West Virginians, as well as our insurance systems. In public health and medicine, the earlier illnesses and injuries are diagnosed and treated, the better. Many of the diseases that we have seen in medical monitoring are latent and may take many years to develop, making them potentially too late to successfully treat before someone would qualify for payment under this bill. Other illnesses may mean that people suffer when this could be prevented or treated. People in rural areas may not have access to the proper doctors and testing without established monitoring programs. At best, this bill would pass along these costs to the private health insurance industry or to taxpayers through Medicare and Medicaid. At worst, people will suffer from serious injuries simply because they could not afford or have access to testing and treatment, or did not know of their exposure and risk, which is a vital aspect of medical monitoring systems. I urge you to vote against this bill to protect all West Virginians. Thank you.
You did a fine job leading off there, Ms. Serber. Ed Hill, followed by Charles Wernz.
Mr. Chairman, I think Mr. Hill's having technical problems. Why don't we?
Okay.
Then we'll try. He's trying to connect.
Okay, thanks, Tony. All right, we'll move on. Charles Wernz, followed by Rich Monahan.
Good morning. My name is Carl Wernz. I'm an occupational environmental medicine physician based in Morgantown. In the past, I've been involved in multiple matters across West Virginia where environmental contamination has resulted of toxic substances has resulted in increased risk of disease in the exposed community. As a physician, one of my roles, in addition to identifying people at increased risk, is also to help make the people better or to help them overcome that increased risk. Unfortunately, when people suffer an exposure, providing monitoring surveillance for the diseases that are directly attributable to the exposure is often the best opportunity to both provide peace of mind to the community, and also to provide early access to care that gives these folks the best opportunity to overcome the disease in question. This includes both things you can identify in the short term, such as lead exposure, which might cause lead poisoning, but you won't know if you don't test people because it doesn't really cause any outward symptoms. And also other longer term diseases such as cancers and neurologic damage that can be seen from certain toxins. I encourage, I guess my recommendation would be that this bill is not in the best interest of the people and the communities across West Virginia that may be impacted by toxic exposure in their community through no fault of their own, and would encourage you to vote against this bill. Thank you very much.
Thank you very much, Mr. Wernz. I appreciate it, or Dr. Wernz, I suppose. And Rich Monahan, followed by Kimberly Tyler Sterling.
Good morning. I am Rick Monahan. I'm a lawyer who represents people who are injured by the tortious conduct of others. In opposing Senate Bill 569, I wanted to note that if you adopt such bill, you will not be joining the majority of jurisdictions which have addressed medical monitoring for individuals who do not yet have a present physical injury. Rather, you will remain in a majority by rejecting such bill and following our Supreme Court's holding in Bowers versus Westinghouse Electric Corporation. In support of this statement, I wanted to note that the American Law Institute has proposed in this past year, 2020, that the Restatement of Torts, 3rd edition, adopt provisions recommending that medical monitoring be adopted as a cause of action, or at least as part of damages awarded for individuals, including those who do not yet have present bodily harm, but who have significant risk of serious future bodily harm as a result of being exposed to the tortious conduct of another. The American Law Institute was formed in 1923 and is one of the most influential private organizations in the development of American law. It is composed of distinguished lawyers, law professors, and judges who issue restatements of law on various topics, including torts. Courts often refer to such restatements in determining whether to adopt causes of action or in determining when such claims, damages, and defenses should evolve. In its proposal, the American Law Institute claims that a majority of jurisdictions which have addressed the issue of whether medical monitoring damages should be awarded, even absent a present physical injury, have held that such damages should be awarded for medical monitoring. It proposes that at least 16 states and the District of Columbia have so held. Such jurisdictions appear to include Arizona, California, Colorado, Connecticut, District of Columbia, Florida, Maryland, Massachusetts, Minnesota, Missouri, Montana, Nevada, New Jersey, Ohio, Pennsylvania, Utah, Vermont, and West Virginia.
Thank you, Mr. Monahan. If you would please wrap your comments. Thank you.
Sure. I urge you to reject Senate Bill 569. There are many diseases which have extraordinarily long latency periods before they manifest. Adopting this bill would deprive many West Virginians of ever recovering damages to catch such diseases at an early stage and have the opportunity perhaps saving their lives or reducing their harm. I would lastly note that it can also harm defendants. If lawsuits are only brought 10 or 20 years after an exposure occurs, many of the defendant's witnesses may be dead or their documents.
Thank you, Mr. Monahan. Appreciate it. Thank you very much.
Thank you.
Kimberly Tyler Sterling, followed by Greg Thomas. Ms. Tyler Sterling, are you with us, or maybe on mute somewhere? If not, we can try again. Greg Thomas, followed by Tracy Danzi. Mr. Thomas, if you're with us, you're on mute. Okay, Tracy Danzi, followed by Gary Zucker.
Hello, my name is Tracy Danzi, and I'm speaking today to oppose SB 569. I've been a nurse and an educator and an advocate in West Virginia for a couple of decades, but I'm also someone who grew up in Parkersburg, West Virginia during the height of the C8 event, and I was a competitive swimmer. Now I have I'm not involved in any litigation, but now I have effects of that. I don't my thyroid does not function, and I'm missing a quarter of my lower body due to rare bone cancers that are not all that rare in the Mid-Ohio Valley. Regarding this bill, I as a nurse reflected on the research that I could find, which I'm happy to provide. Our own National Institute of Health has been very clear in their direction of medical monitoring programs and where they believe they should go. When making a law regarding medical monitoring programs, you should consider the public health as heavily, if not heavier, than the liabilities of the corporation. I have two quotes to read to you out of two pieces of research. One is called Ethics and Principles in Medical Monitoring of Populations Exposed to Environmental Hazards, and it's very clear and easy for a layman to read. The first quote that I would bring to your attention is that they say the principle underlying medical monitoring programs for individuals or groups exposed to environmental contaminants is for early detection and correction of adverse health conditions or risk factors related to exposure, thereby reducing the likelihood of premature morbidity, disability, or mortality. So the very purpose of these programs is to identify illnesses before they become exaggerated and become a major illness. Then I would go on to bring out this quote as well in their research. In some legal cases, courts have required that medical monitoring be restricted to only those markers or endpoints specific to the exposure. We argue that this strict requirement is medically unsound, statistically invalid, and ethically indefensible. And I argue West Virginia.
Thank you, Ms. Danzi. If you could please wrap up your remarks. Thank you.
I argue that West Virginia is taking it a step further and therefore putting it on the backs of the West Virginia taxpayer. I'm opposed to SB 569.
Thank you very much for being with us. Gary Zucker, followed by Ed Gentle.
Thank you, Mr. Chairman, and members of the committee. I appreciate the time to make a statement this morning. My name is Gary Zucker. I'm Executive Director of West Virginia Citizen Action. We are a consumer advocate group and have been up there at the Capitol for the last 3 or 4 decades advocating for the interests of the citizens. And I'm not a doctor or a lawyer, but citizens want clean air and water that won't cause them to get sick or develop environmentally caused diseases. And we think that this bill 569 is really not good for public health. It turns our medical monitoring law on its head. The horse has left us. Look at the situation in Parkersburg with studies of that population that determined the various illnesses that exposure to C8 caused. If large multinational corporations are going to use our population as guinea pigs, we at least deserve access to the medical monitoring that is not a sham. If the goal of this bill is to make sure that awardees do not divert awards into other uses, there are better ways to do this. Amend this bill to make it clear that awards in such cases must be placed into trust for medical costs only. Please do not pass Senate Bill 569 as it is. Make it address the problem. Don't gut the whole process to fix a minor perceived problem in the code. And I thank you.
Thank you very much, Mr. Zucker. Ed Gentle, followed by Anthony Magistro.
Good morning. My name is Ed Gentle. I administer settlements for a living, and I wanted to report how medical monitoring is working in West Virginia with respect to the 2 settlements I administer. the zinc smelter settlement in Harrison County involving 4,000 claimants, and the Mingo County coal slurry settlement involving 700. With both of those, we've had early detection, which helped claimants get medical care outside the scope of the program to prolong their lives and have higher quality of life. Also, they both come in below budget. A model case to look at is the Fernald case in Ohio. It had similar results. I wanted to point out that the Bowers test in West Virginia works very well. You have to show significant exposure to a toxic substance. It's got to be shown to be caused by the defendant, and the plaintiff is at increased risk in their tests to detect that early. So that works very well. From the defendant's perspective, I found that it's very beneficial. I've seen cases where the defendant is found not to be liable for punitive damages because medical monitoring is a responsible thing to do in reaction to a hazardous substance. Also, personal injury claims are deferred and often don't occur, and it helps the defendant wrap things up more cheaply and earlier. So I really think it's a good remedy while carrying out the adage that early detection is the key to cure of disease. Thank you.
Thank you very much. Anthony Magistro.
Can you hear me?
Yes.
Loud and clear.
Thank you, Mr. Chairman. My name is Anthony Magistro, and I'm an attorney practicing here in Charleston, West Virginia. I'm opposed to SB 569 because those who expose West Virginia residents to hazardous substances should be the ones to pay to monitor and diagnose the latent diseases that they cause. Medical monitoring is not a claim that occurs in every lawsuit, but the remedy is a valuable legal tool in appropriate cases. And I'd like to take a minute to tell you about one case I was involved in. In the late 1990s, a popular diet drug combination, fen-phen, was discovered to be linked to heart and lung disease. Millions of Americans and tens of thousands of West Virginians had taken the drug. For the benefit of consumers, the Food and Drug Administration requires that all companies include drug risks on their label. Yet, despite the manufacturer's awareness of the health consequences caused by its drugs, it did not fully report the risk of taking the drugs or even put any warning on the label. Records showed that the company had been informed of over 41 drug-related heart and lung cases, but informed the FDA of only 4 cases to be inserted on the drug's label. Documents established that company officials discussed their concerns regarding and proposed amending the label, yet delayed years before doing so. Ultimately, the FDA banned the drug as too dangerous for human health. So the heart and lung diseases caused by these drugs appeared later and were often undiagnosed, allowing diseases to progress. In the early 2000s, however, following litigation, a settlement was reached with the manufacturer, and West Virginia victims were provided medical monitoring to diagnose this hidden disease. Because of our strong medical monitoring remedy, West Virginia was picked to be the first jurisdiction to provide that remedy to its citizens. I was a lawyer who was responsible for implementing this medical monitoring program, which was the first widespread use of the remedy in this state. Thousands of West Virginia residents received the simple diagnostic testing, and hundreds of cases of undiscovered heart disease were discovered, allowing those West Virginians to receive treatment. In many cases, the early treatment made open heart surgery unnecessary. Medical monitoring in that case was paid for by the company who so callously put West Virginians at risk and ultimately saved lives. I had 2 clients that I am sure had their lives saved by that diagnostic treatment. SB 569 will prevent future victims from being saved and shift the cost to our citizens. Please reject it.
Thank you, Mr. Magistro. I'm going to go back. We had a few that were absent, so we'll see if they've joined us. Is Ed Hill with us? Ed Hill. Okay. Kimberly Tyler Sterling. Kimberly Tyler Sterling. Okay. Greg Thomas. I see. Oh, there's Mr. Go ahead, Mr. Thomas, you're on mute. Oh, there we go. And then I see Mr. Hill's joining, and Mr. Hill, you will follow Greg Thomas. Greg Thomas, go ahead.
All right, Greg Thomas from South Charleston, West Virginia, representing the American Tort Reform Association. Um, West Virginia is one of the few states in the nation where courts have recognized medical monitoring as an independent cause of action, despite there not being any physical injury. This has been a bill that has passed the state Senate a few times. We're encouraged that it's being considered by this committee, and hopefully it'll get through this time. What we're trying to do is what we're asking the legislature to do here is to just clarify that the long-standing tort law of there has to be an injury for there to be there has to be evidence of an actual physical injury for there to be a cause of action. This is a fundamental, I'm not a lawyer like a lot of the other personal injury lawyers that are on this Teams call here, but I do know that this is a fundamental principle of tort law that's been a requirement for a long, long time. There's only a handful of states that do this. In a couple of the states that were like Louisiana, where the court did create this, just like the West Virginia court created it, the Louisiana, legislature stepped in and enacted a piece of legislation, just like we're asking you all to consider with this bill. The United States Supreme Court has recognized that tens of millions of people suffer exposure to harmful substances every day, and it can't be that every single person can use that as a cause of action. So the U.S. Supreme Court has not recognized this cause of action that was created in the West Virginia State Supreme Court. Essentially what they're doing here is they're asking for medical monitoring of claims based on speculation that it may one day happen.
Thank you, Mr. Thomas. If you could just wrap up your remarks. Thank you.
All right. Look, West Virginia is way out of line on this. This is one of the few, we've been a judicial hellhole forever, and this was one of the main reasons why we have a medical monitoring lawsuit that's way, way out of whack with the rest of the country. And this legislation would get us back in line with the rest of the states. And, we definitely approve of it and would appreciate your support of this bill.
Thank you very much. I see that Ed Hill has joined us. Mr. Hill, good morning. You're up. You're on mute, my friend.
How about that?
That's perfect.
Okay, thanks so much. Thank you for the opportunity to speak against this bill. I'm a lawyer here in Charleston, West Virginia. I've worked on two cases, significant cases involving medical monitoring. There are multiple states that have this medical monitoring, and it serves a very viable purpose. One of the cases that I've worked on involved the corporation of DuPont and the chemical C8, or ammonium perfluorooctanoate, or also PFOA, that DuPont allowed to seep into the drinking water of Parkersburg area and areas in Ohio. Medical monitoring was established there. It has been established that drinking this water with significant exposure, there's a criteria for it, causes kidney cancer and testicular cancer. What medical monitoring does is, if you have had significant exposure to a toxic chemical and it's someone else's fault, then the idea is that periodic testing for that will allow for early detection and early treatment and prolonged life. Another case I've worked on, and this has worked very well with the DuPont medical monitoring for C8. Another case involving DuPont, involving the Spelter smelter in Harrison County, where DuPont was responsible for a smelter slag pile that contained arsenic, cadmium, lead, and also zinc. And well known that significant exposure to these chemicals in this slag pile caused lung cancer. Several people have died from lung cancer as a result of it. Medical monitoring was established. about 500 people. This was in 2011. It's still ongoing. It was created to last for 30 years. There's a administrator for it. We know that people have been diagnosed early with lung cancer and treated for it. So and enabled the prolonging of life as a result of this early testing and diagnosis and treatment.
Thank
So
you, Mr. Hill. If you just please wrap up your remarks.
medical monitoring serves a very viable purpose. In the long run, it saves corporations money because instead of paying for a wrongful death, they're paying for early diagnosis.
Thank you very much for being with us. Is Kimberly Tyler Sterling on? I wanted to give her one last chance if she was on with us this morning. Does not appear so. Thank you so much, everybody that joined us this morning. We value your input in the process. We hope that we've made it available to you and accessible. It appears that this is the end of the registered individuals. If there are written materials that you would like to submit to the committee, we would encourage you to do that. If you feel so moved, send those by email to our clerk, who is Mark White, and his email address is mark.white@wvhouse.gov, and we will be happy to pass those out to the members of this committee. Thank you, everybody, again, and I hope everybody has a wonderful weekend. This public hearing is adjourned. Thank you.
Thank you, Mr. Chairman.
Thank you.